Buenas tardes a todos. Muchas gracias por vuestra presencia y yo quiero empezar mandando un abrazo muy fuerte a Tonio Borg, que sé que está pasando un momento muy difícil, que le vamos a tener a su hermano en nuestras oraciones esta noche y sobre todo quiero agradecerle el esfuerzo que hace estando en la tarde de hoy. Simplemente breves palabras para decir que la protección del embrión humano está en la raíz de nuestra existencia. Nosotros nacemos para defender la vida y nacemos para defender ese embrión humano y por eso yo quiero comenzar diciendo que esta es la raíz de nuestra existencia, de nuestra plataforma, de nuestra federación One of Us. Y dicho lo cual, quiero decir que es una alegría poder hacer este acto desde Malta, organizado desde Malta, y para nosotros es un honor comenzar este acto con personas como Tonio Borg, y a partir de ese momento tenéis la palabra. Gracias por vuestra presencia, por el sentido del acto y porque hoy es un día muy especial para una persona como Tonio Borg. Muchas gracias.
Sí, pues muchas gracias, Jaime. En primer lugar, desearos, por supuesto, a todos, daros las buenas tardes y agradecer a los panelistas que hoy nos acompañan en este seminario organizado por Life Network Malta y por One of Us. Quiero agradecer también a Tonio Borg de manera especial su presencia y que nos acompañe hoy. Y también muchas gracias a todos los participantes que desde los distintos países de Europa están conectados en este acto. El seminario de hoy, como decía don Jaime Mayor hace unos minutos, se dirige precisamente al núcleo central de One of Us, de la Federación, a su razón de ser y a su propia historia. Hoy, como desde los inicios de One of Us, como iniciativa ciudadana europea, One of Us tiene como principal misión la promoción del reconocimiento de la dignidad del embrión humano en cada etapa de su desarrollo. Partiendo desde la razón y también desde la ciencia, es importante señalar que la evidencia embriológica nos muestra que el embrión humano es un ser humano completo, aunque obviamente inmaduro, pero no es una mera parte. Por ese embrión humano, desde la concepción en adelante, está absolutamente programado para desarrollarse activamente a sí mismo hasta la siguiente etapa de la madurez a lo largo del camino del desarrollo humano. Desde esa evidencia científica, hoy vamos a analizar con nuestros ponentes los aspectos que atañen a la protección del embrión humano. Y en primer lugar, quería dar la palabra al doctor Domenico Coviello de Italia, médico genetista del Instituto Científico Gaslini de Génova y que nos va a hablar de la protección embrionaria y las pruebas prenatales, los aspectos médicos y éticos. Doctor Coviello tiene la palabra. Muchas gracias.
Thank you very much, Anna. I will share the screen now. And I will start. Okay, so thank you for inviting me, and it's a pleasure to share with you what I can say about this embryo selection and prenatal testing concerning medical and ethical aspect. So what my talk will speak vocabulary, then I will mention classical prenatal testing, and then I will speak about pre-implantation testing, and in the end, some ethical aspect. So the first part is fertilization and vocabulary. So everybody we know that as Anna was saying, the life starts when the two genome, the genome from the mother with 23 chromosomes plus the mitochondrial DNA that is in the egg will meet with the 23 paternal chromosome, and this will be the new starting life with 46 chromosomes. And is really a miracle that when we see this event that one sperm will enter the egg, and then nobody other of the sperm will be able to enter these eggs, and this is already something very, very a miracle. So vocabulary. We start with zygote. The encounter between the female gamete oocyte and the male sperm, the sperm, give rise to the development of the zygote, the first cell, about 20 hours after the fertilization of the egg. The embryo, further cell division between 48 and 72 hours after fertilization of the egg. Each development day is characterized by certain number of distinctive and clear visible cells that are called blastomeres. So in the first 48 hours, we will have 24 cells, 24 blastomere, and in 72 hours, we will have 612 cells. Next step will be blastocyst. So the most advanced embryonic development 5-6 days after fertilization. There are no longer distinct blastomeres, but numerous small cells that are arranged in a peripheral way to cover a central cavity filled with a liquid called blastocyte. In nature, this is at this stage that the embryo will implant itself into the uterus. And here we can visualize all these stages. So we have the single cell here, and then 2, 4, and so on, and then we'll divide, and here we can see the cavity. This is a cartoon, and here also is the same cartoon with day 2, day 3, and then day 5, there is this blastocyst. These are the real pictures that are a little more hard to understand, but you can see here in day 1, the 2 nuclei of the 2 cell sperm and oocyte will fuse and will start with the first cell, the zygote, and then will be the division, 2 cell, 4, and so on. And here is again a cartoon just to show you that these very red cells are the cells that will start to make the embryo. All the other cells around are the annexed. So cell that will contain the amniotic fluid and we will give rise to the placenta. Here is to show where all these divisions happen. So as we know, the fertilization is in the end of the fallopian tube. And then as far the division go on, the zygote will follow the tube to go down into the uterus. And then into the uterus, the blastocyst will implant, as we said in day 5. Here is just a configuration to show you how the blastocyst will attach to the uterus mucosa to start to link and go inside the uterine mucosa. And here there are some other phases. So day 6, 7, and then 7, 8. So we'll enter the mucosa, and you see that the blastocyst is inside, and will start to create this reticulus that is called chorionic villi. And this is one of the tissue from where we do the regular invasive prenatal diagnosis. And this will introduce me to the classical prenatal testing that most of you will know. And here is the scheme. So we know that in the beginning, the classical test is ultrasound, just to see the fetus. Then we have biochemical screening to have some kind of alarm on possible metabolic stuff that are not going well. Then we have the chorionic villi analysis, and we can have the karyotype from villi, and we can also do DNA analysis. And then amniocyte. This is a little later, and these are cells that are in the amniotic fluid. And also from this cell, we can do karyotype or DNA analysis. And then, as you may know, now there is a new technique that from the blood of the mother, you can have a circulating DNA, free DNA. You can analyze this free DNA to avoid the invasive prenatal diagnosis. These are just the timing of this sampling. So we have the 10-12 week of gestation for chorionic villi sampling, and 15-18 weeks for amniotic fluid that is in the second trimester. And then there is fetal blood that is now very, very rarely used. Many years ago was one of the tissue, but now is not used anymore because DNA analysis can clarify most of the things. Now we go to the third step, pre-implantation testing. And here we can see that to do the pre-implantation testing, we need to go through the fertilization in vitro and then embryo transfer. And as you may know, if these do not happen in vitro, just naturally putting together the eggs and sperm, then there is the ICSI, that intracytoplasmatic sperm injection. Anyway, we have this starting group of cells, and in the beginning they were using the blastomeres, a single cell. Now they grow more, as we can see in the next pictures, grow more, and they do not use anymore the blastomer, but they use some cell from the wall of blastocyst. And from this we can do DNA analysis or cytogenetic analysis. So this we saw this image, and this was the natural story, and we have to. I was putting this back just to remind. All the time the zygote and also the blastocyst is inside the mother, so is in intimate connection and in relationship with the mother. What happened in the in vitro fertilization of course, the route is changed. So the oocyte, there is the pickup of the egg, and then outside, so in vitro, in a test tube, sperm and eggs are put together, and then happen in vitro fertilization. Then there is the embryo selection, because this is the procedure, and then when you have chosen the embryo that seems to be the best one, then you can have the embryo transfer. So embryo selection, of course, you look for morphology, for example, but now with pre-implantation testing, you can also see DNA on chromosome analysis on these cells. And so this is to summarize. We can see the blastocele. So these this cell on the top here are that one that will give rise from the embryo. This blue one are just the annex. And so PGD analyze only trophoblast, so only the trophoblast, that is the tissue that will give origin to the placenta. This is to have more safe for the child, but this is also to let you know that in this technique, you are not analyzing the fetus, but the annex. So could be not the same thing. So the technique is not so precise, and this is not always told the people that go to do PGD. Now we go to the concern, some ethical aspect. And so we can see that there are many papers on concern on this technique. This is only one title, just that was summarized the cycle, and I will mention only the main concern. So we can have the scientific concern, and what I said is, one is limited diagnostic value. So I speak with many women that come to our institute after have done already in vitro fertilization, because things are not working, and only after they are gone through this this route, they understand that not all the diagnostic are very precise, and there still a lot of doubt will remain even after the answer that they will give you. But unfortunately, this is not explained so well before they start this route. Then epigenetic consequence. So I was mentioning that the environment where the embryo is growing is not the maternal environment, but is in vitro. And so epigenetics is something that is related to modification not on the single basis of DNA, because so if you sequence the DNA, you don't see any change in the sequence, but there are factors on the top of DNA, like that they can block the expression of some gene, or they can enhance the expression of other gene. And this is through the environment. So epigenetics is a very big field of study now, and is study all the interaction between environment and DNA, activating or inactivating some gene. And this can bring to imprinting effect on the fetus. And these are very hard to see at birth, and then you can see maybe after a long time. And what I would like to point out is that for many therapeutic production, there are many checks that you have to do before to put a drug on the market. But for this technique, they will have not allowed to see the consequence. This just speaking about the privacy. So in the name of privacy, was not able to conduct study, long-term study, I will say 5-10 years after in vitro fertilization to see the consequence. So we have very low data because speaking about privacy was not possible to follow all this pregnancy. And now the ethical concern. So active action. So we are in front of an active action and premeditation to select human being on the basis of the phenotype. I would like to stress this point because many people say, well, since we have already prenatal diagnosis, why we cannot have pre-implantation diagnosis? And I point out that we are in two completely different situations. In prenatal situation, there is no active action because it was a natural fertilization. So the medical doctor is in front of a woman and a fetus that they are naturally conceived. Then the women can ask about the health of the fetus. And then so prenatal diagnosis will inform on the health status of the fetus. It's not obligatory to terminate the pregnancy. Is only so there is no medical act that premeditate to terminate the pregnancy. When you do PGD, pre-implantation diagnosis, you need to do in vitro fertilization. So this is an active planning of select fetus on the phenotypes. And so we have an active action in production additional healthy human embryo that could be not implanted, but frozen or maybe lost. And this is what happened. So this is what I would like to point out with these 2 points. And then the third point is the possibility to embryo modification, because you have the embryo in vitro, so in a test tube, and so you can also modify, and therefore changing also, if you modify the embryo, you automatically will change the germline, so the gamete of the fetus when he will become an adult, and then will possibly create a new modified human species. So this is one of the most concerned that we have now. Here is just to clarify some of this point. And so, of course, if we have a meiotic change of chromosome, you will have all the cell with this, for example, trisomy. So will be easy to see also on pre-implantation diagnosis. But we know that we can have also mitotic changes. So not all the cell will have these changes. So you cannot be so precise. And in this case, only few cells will have, for example, trisomy, and PGD can miss this diagnosis. So it's not a precise method of diagnosis. And I remember you the epigenetics. So this is DNA, and you can see this blue protein or factor. So all this kind of factor can go on the top of DNA and act as open block or open DNA. So can be many genes that can be changed, and this will be seen maybe later on, maybe 10 years later. Some epigenetic factor can be also seen in the next generation, so in a second generation. So it's very complicated aspect. And then the last big concern is the revolution to change, to modify the DNA. So here the part of this title is with the new gene editing technique, we can transform life. But should we? So of course, people that have used this new gene editing, CRISPR-Cas9, most of you will know this name, of course say that we will use this for gene therapy to fix abnormal gene that can lead to disease. And with this technique, you can change one single base or maybe some bases. But this technique can be used not only for genetics. Once you have this technique work, you can use for maybe other scope, changing completely some gene. And so this is the new concern of post-genomic era. So research experiment to get human, animal, chimera, embryo have highlighted this new problem. And maybe all you know about the chimera, about monkey and human. So chimeric embryonic cells have the potential to generate chimera embryos and therefore chimera fetuses, of which we know almost nothing. So already in 2015, as you've seen these, there are the two of most prestigious journal in science. They were saying and explain this concern, because with this CRISPR-Cas9 that you can change DNA, we don't know exactly what kind of baby we will have. And of course, what are the concerns? So of course, this technique that was fast, simple, and cheap was quite important for modify plants, for example. And in this case, maybe it was not raising particular objection, but already in other hand, it's possible that this experiment will change, for example, pet, just to have this new kind of animal that people can ask or want to do. And of course, what is even more dangerous, however, is the real concern that address to the editing of human embryo, as we said. And of course, we know that there are so many clinics that saying that they want to help people that are infertile. They can offer many choices to client, and so you can even on your mobile phone, you can order some kind of gamete with particular characteristic. And so this is really what we concern. Also here we have a cover of Time magazine, and we see that if we sequence all DNA, even at the pre-implantation stage, we will find so many predisposition genes for many diseases, but we don't know if all these predisposition will happen really, because epigenetic can block some predisposition or can favor some other. So what Time was saying that if we do this, maybe no child will be considered good for proceed and born. So of course I'm near the conclusion. So what we can say is that in the wrong hands, all this technology could be used for not clearly purpose, and of course we can use technology for do good science, but also for negative science. So the discussion on the social, ethical, legal aspect of this new genetics must not only involve scientists, doctors, philosophers, theologians, politicians, but it must involve all people because the future of humanity is at risk. And with this, I thank you from Genova and from Gaslini Institute that is near the sea and where I enjoy to work. Thank you for all your attention.
Muchísimas gracias, doctor Coviello. Ha sido muy interesante y la verdad que a mí me surge una reflexión, y es en estos tiempos en los que la elevación de la protección del medio ambiente llega a límites a veces insospechados, ¿cómo puede ser que esta protección no se dé al ser humano en la primera etapa de su vida, en la etapa embrionaria, y tratamos de reformular cualquier actividad? Más tarde tendremos un turno de debate, que quizá esta sea una pregunta que podamos tener todos en mente, pero ahora quería dar la palabra a Tonio Borg. Tonio Borg es excomisario europeo de Salud y ex viceprimer ministro y ministro del Gabinete en Malta. Es miembro de la ejecutiva de One of Us y trabajador incansable en defensa de la vida. Hoy es un día complicado para él. Quiero agradecerle de nuevo que esté con nosotros a pesar de las circunstancias, y querido Tonio, aparte de agradecerte, por favor, queremos saber un poco cuál es la historia legislativa en Malta respecto a la protección del embrión humano. Tienes la palabra, Tonio.
Thank you, Anna, for your kind words. In my intervention, I'm going to give a brief history of embryo protection legislation in Malta. And as a background, please remember that Malta is the only European Union member state which still considers abortion to be a criminal offence. Now, I was Minister for Justice between 2003 and 2008, and I and my team were involved in the first drafting of the first Embryo Protection Act. At that time, there was no legislation in Malta regarding intro-vitro fertilization or the protection of embryos, except that the criminal code provided that it was a criminal offence to willfully terminate a pregnancy. Now, when it came to the drafting of the Embryo Protection Act, by the way, the Embryo Protection Act was then approved in 2012 when I was no longer Minister of Justice, because I was Minister for Foreign Affairs. I relied a lot on the 1990 German legislation entitled Embryo Protection Act. And even this is important. I wanted, on behalf of the government, to send a message that this act is there to protect the embryo and regulate certain things connected with the embryo. I'm saying this because while the German legislation is entitled Embryo Protection, others have a so-called impersonal title, like Human Fertilization Regulation Act. Okay? Here the message is clear. This is an act of Parliament to protect the embryo. And I must say that this act was approved unanimously by the Maltese Parliament, which therefore makes it extremely strange how in 2018 then it was altered, inserted. Anyhow, so it was based on the German legislation of 1990 and also on the law number 40 of 2004 of the Italian Republic. So certain positions are taken from the German legislation and others from the Italian one. And then the draft law, as I said, became an act of parliament in 2012 and consisted of short, simple precepts, which is the case with the German law. Now, the first question which we had to tackle was who is to be entitled to perform a medically assisted procreation. And we decided in favor of not only heterosexual married couples, but also those couples, heterosexual, who were in a stable relationship. At that time, there was no law regulating relationships outside marriage or same-sex relationships. And I argued that even a Christian or a Catholic legislator, while getting inspiration from Christian belief, cannot impose just one form of family relationship on the entire population. And the argument was that if performing the conjugal act between unmarried couples was not illegal, nor should it be legal for an unmarried couple to have a child through IVF. However, in order to provide for certainty of parenthood, the couple who would be participating in the medically assisted procreation had to give their consent in writing, and this is still in the law, to be considered as parents of the child to be born for all legal purposes. This would guarantee the legal certainty of fatherhood and motherhood for the child when it is born. And similarly, anonymous sperm donation and surrogate motherhood were prohibited for the same reasons. We shall see that now anonymous sperm donation is allowed, but surrogate motherhood is still not allowed. The bill, which then became law, prohibited artificially fertilization of an egg cell for any purpose other than that of bringing about a pregnancy. This was called from German law. This zero preservation of embryos, the freezing of embryos, this was totally prohibited, with only two exceptions. One, when in the circumstances where the transfer of fertilized embryos into the prospective parent was not possible due to grave and certified force majeure, like when the woman fell ill and therefore after the fertilization of the embryo, circumstances not predictable at the moment of fertilization. And secondly, in any cases of breach of provisions of this act in order to preserve the embryo's life. We shall see that recently this prohibition of freezing was changed in part. There was the prohibition of selection of sex, the prohibition of human cloning, the prohibition of artificial fertilization without the consent of the man or woman from whom the reproductive cells are taken, transferring an embryo into a woman without her consent, prohibition of artificial alteration of human germline cells, and the prohibition of formation of chimerae and hybrids. There was also in the bill a quasi-total prohibition of research on human embryos, the only exception being when this was done exclusively for therapeutic and diagnostic purposes in the interest of the health and development of the embryo itself, and there is no undue risk to the embryo and the mother. The storage of fertilized embryos was not allowed, and not more than 3 egg cells from one woman within one treatment cycle could be fertilized. And this was in line with the German law at that time. And finally, and this is important, the willful destruction of a human embryo was considered to be a criminal offense. And this is still in the law. Thus, the embryo, whether cryopreserved or not, cannot be willfully destroyed under any circumstance. This shows that the embryo is recognized by law to have a value in itself, as even if the IVF treatment of a couple has been successful, the remaining embryos still cannot be left to perish. However, things changed in 2018 when the amendments to the Embryo Protection Act were introduced. And according to the health minister of the new government, this was done to improve the success rates of IVF and to make IVF available for more people. And now a maximum of 5 eggs can be fertilized within a treatment cycle, provided the prospective parents expressly provide their consent to the cryopreservation of embryos and to the donation of fertilized eggs if necessary. So you're only allowed to fertilize 5 eggs rather than 3, provided you accept that the extra fertilized eggs will be donated. Only 2 embryos can be transferred into the prospective parent within each treatment cycle, And assuming that the fertilization has been successful, the rest of the embryos are cryopreserved for future use. Therefore, the freezing of embryos has featured more frequently now in the IVF procedures according to the new law. So what happens with the embryos which cannot be transferred into the prospective parent within a treatment cycle? They are frozen in licensed tissue establishments for future use by that prospective parent. However, the freezing of embryos is to be regulated by an agreement between the prospective parent or parents and the licensee, the authority which regulates IVF, subject to the prior authorization of the authority, and shall have a maximum term of validity of 5 years. So the agreement has a maximum validity of 5 years. What happens after the 5 years, which can be renewable up to a maximum permissible age for the transfer thereof into the prospective parent? So again, when the maximum permissible age for the transfer of the embryo into the prospective parent is reached, the authority, which is established by the Act, can authorize the donation of the frozen embryo. Now, the practice of cryopreservation has raised concerns of embryo loss, as not all embryos will survive thawing. Some believe that this practice is not morally acceptable, as it suspends the life of a human being in its earliest form and does not treat human embryos as persons with dignity. The fact that the crime of abortion is still on the Maltese statute book, yet the 218 amendments make embryo freezing widely available, even though not all embryos will survive the freeze-thawing practice, has been cited as being an example of the failure to harmonize different understandings of dignity in certain fields of Maltese legislation. And the position paper published by the Maltese Catholic Church raises the concern that embryo freezing is likely to create embryo orphanages, which concern was further raised even in an opinion paper in 2018 published by academics at the University of Malta. This is because there is no guarantee that the frozen embryos will in fact be adopted, and they may be left there indefinitely if the supply is larger than the demand. Besides, if 5 embryos are fertilized and only 2 are chosen for implementation, the best 2 will be chosen in order to have a higher probability of success. This means that the rest will be less healthy embryos, which will reduce the chance of these embryos being adopted. Besides, the 2018 amendments, in line with the introduction in 2014 of same-sex marriages, allow same-sex female couples to participate in IVF through gametes provided anonymously. So even the prohibition of anonymous donation of sperm cells was lifted. Now, Article 2 of the Act defines embryo as meaning the human organism that results from the fertilization of a human egg cell by a human sperm cell, which is capable of developing, and shall further include each totipotent cell removed from a human embryo or otherwise produced that is assumed to be able to divide and to develop as a human being under the appropriate conditions. This definition leaves no doubt that the embryo is human. Every embryo has a unique gene set which is specific to that human being. Now, there are 4 values which I take from the instruction Dignitas Personae of the Congregation of the Faith of the Catholic Church on certain bioethical questions, and these 4 values are the couple's entitlement to administer and have an interest in the planning of their own offspring, the respect of human life from conception, the defending of the family and marriage, and at last, finally, the protection of the unborn child's interest. the 2012 Act had established the Embryo Protection Authority to guarantee that all procedures under the Act abide by the law. In 2018, this authority was given the power to endorse adoption of unused frozen fertilized embryos. The rights of the prospective parents whose gametes have been used to create the embryos come to an end when the Embryo Protection Authority becomes the curator of the frozen embryo. It is not clear, however, and this is of concern, as to what rights the prospective parents have on the frozen embryos before the occurrence of these reasons which enable the giving for adoption. One might expect that if the frozen embryo is equated to a child, then the parents would or should have parental authority. However, this point is not clear in the new legislation. So the introduction of routine embryo freezing in 2018 has affected the protection offered to the embryo by law. This practice is being done as a measure to increase the effectiveness of IVF treatment by harvesting more eggs at once and fertilizing up to 5 embryos. This is done if there is consent from the prospective parent for the potential adoption of the remaining embryos which would have been frozen. Therefore, the freezing of embryos in a way saves the excess embryos from perishing, as instead they are kept frozen and made available for adoption. However, this can be seen as a step in the direction of balancing out the interests of the prospective parents in having a greater chance of success of having children at the expense of the protection given to the embryo. This is because putting the life of the embryo in a frozen limbo is not in the interest of the embryo or resultant child. The main problem discussed was that there is no guarantee for all embryos being adopted. So this brings forward the notion of human dignity, which is inherent in every human being. If one were to consider the frozen embryo as a person, and of course we do, it would not be acceptable to keep their life suspended. In this way, frozen embryos are given more importance as a means for a couple to battle infertility and grow their family. This is prioritized over giving maximum protection to the frozen embryo as a human person from conception. And I conclude by saying that the developments in this field are overshadowed by a crisis in human values which runs across Europe. This puts even a heavier burden on all of us, even if we are in a minority, to strive for the protection of the value of life. The satisfaction of desires, even of parenthood, cannot prevail over the supreme value of life. Ensuring that our voices in favor of life are heard is a duty which transcends any particular religion and is based simply on the value of human dignity. Thank you very much.
Muchas gracias, Tonio. Muchísimas gracias por tu presentación y bueno, pues te mandamos un abrazo y muchos ánimos desde todos los que estamos hoy aquí participando. Desde luego la reflexión es que efectivamente el embrión humano no es una herramienta para el padre, es un ser humano. A continuación le voy a dar la palabra al juez Vincent de Gaetano, que ha sido presidente del Tribunal Supremo en Malta y es también un juez del Tribunal Europeo de Derechos Humanos. Interviene desde su experiencia profesional y formación académica como jurista para hablarnos de la protección de los embriones humanos y la libertad de conciencia. Tiene la palabra, señor de Gaetano. Muchas gracias.
Thank you, Anna. Thank you for inviting me to participate in this seminar. Now, the topic of embryo protection is certainly one of the most controversial subjects of the last 5 decades and has in many respects been intertwined with the issue of abortion. with one important difference, of course. One can, in effect, nowadays, destroy an embryo without performing an abortion in the classical, clinical, or legal sense of the word. The underlying ethical, moral, and for the most part legal principles, however, remain the same. All these principles have to answer to a basic question. What are we really dealing with here? Are we dealing with just a blob of protoplasm, or are we dealing with human life? This is the fundamental question that transcends all legal considerations. An embryo, and indeed an unborn child, may not be a person in legal terms, even though in many jurisdictions an unborn child may inherit and transmit rights. But we are still dealing essentially with human life. Now, in this brief intervention, I would like to deal with three very general topics. The first is how the unborn is dealt with in international instruments. Very often we tend to forget these international instruments. The second is how the unborn has been dealt with in the case law of the European Court of Human Rights. And third, how domestic legislation dealing with embryos could impact on the freedom of conscience of third parties, notably of people involved in the medical profession. Now, not only is there no duty on the part of states to permit abortion, but also there exists a positive obligation, in my view, under international law to safeguard the right to life of the unborn. States should therefore have a strong interest in determining, in accordance with their national context, how they will protect the right to life of the unborn. As we know, unfortunately, the discourse is very often in the opposite direction, guided or perhaps misguided by the catchphrase of reproductive rights. An international obligation to legally protect an unborn's right to life can be gleaned from treaty law, such as the American Convention on Human Rights, which includes an obligation to legally protect every person's right to life from the moment of conception, that is, before viability. Article 4, subarticle 1 of the Convention has been identified by many scholars as the most emphatic recognition of the unborn's right to life to date in international human rights law. I quote Article 4, subarticle 1, which reads, "Every person has the right to have his life respected. This right shall be protected by law and, in general, from the moment of conception. No one shall be arbitrarily deprived of his life." Article 6 of the Convention on the Rights of the Child, adopted in 1989, explicitly recognizes the inherent right to life of every child and establishes the obligation of states to, I quote, "ensure to the maximum extent possible the survival and development of the child," unquote. According to Article 1 of this convention, a child is defined as, I quote again, "every human being below the age of 18 years, unless under the law applicable to the child, majority is attained earlier," unquote. This therefore provides an upper limit as to who is a child, but does not provide a lower limit on when the status of child attaches. So we go to the preamble of this convention, which recognizes that, and I quote again, "the child needs special safeguards and care, including appropriate legal protection before as well as after birth," unquote, with no reference to viability considerations. These provisions clearly imply the recognition of a form of personhood of the unborn child and the rights attached to that status, or otherwise stated, that even before a child is viable in the classical Roman law sense of the word, it is deserving of protection. Then there is Article 6, subarticle 5 of the International Covenant on Civil and Political Rights, of 1966, which protects the right to life of unborn children whose mothers have been sentenced to death. As the travaux préparatoires of this convention make clear, the intended understanding of this provision is that, and I quote, the death sentence should not be carried out on pregnant women to save the life of an innocent unborn child, unquote. Similar concerns over the protection of unborn life are also found in one of the treatises of international humanitarian law, what we used to call in the past the law of war. Nowadays, it's international humanitarian law, namely the Geneva Convention relative to the protection of civilian persons in time of war, according to which, and I quote, the wounded and sick, as well as the infirm and expectant mothers, shall be the object of particular protection and respect, unquote. It is thus evident, to my mind, that the meaning and scope of the right to life as set out in international human rights instruments recognize the unborn child at whatever stage of development, and by necessary extension, also the embryo as a rights holder. The position as regards the case law of the European Court of Human Rights is more complex and, in effect, by far less friendly towards the unborn. The European Convention, which the court is tasked with enforcing in the absence or in default of its application and implementation, or in default of proper application or proper implementation by member states, this convention was drawn up and opened for signature and ratification only 5 years after the end of the Second World War. It was intended to deal primarily with those kinds of abuses of fundamental human rights prevalent on the European continent immediately before, during, and immediately after the war, and therefore embryo protection and abortion did not really figure in the background to this treaty. As we know, the convention came into force in 1953. Then in 1954, the European Commission for Human Rights, which has since been abolished, was set up. And in 1954, the European Court of Human Rights was set up on a part-time basis. From its inception up to the mid to late 1970s, the European Court of Human Rights struggled to maintain narrow legal authority. The court's judgments influenced the litigants involved in these disputes, but did not cast a broader normative shadow beyond the target case and the specific state concerned. The court's limited influence was, in a sense, an artifact, first of its own limited caseload at the time, during its first 15 years of operation, which limited caseload was due to the fact that key states, notably France and the United Kingdom, were unwilling to accept the court's jurisdiction out of fear that this court would meddle in the decolonization struggles of the period. Therefore, of its own motion, the court responded by giving a relatively restrictive and state-friendly interpretation of the convention provisions. According to a number of scholars, in fact, this was done purposely to facilitate states' acceptance of the entire human rights system. And in a sense, it worked as more states came fully on board. We see the court's docket expanding, and between roughly the 1980s and the late 1990s, the court assumes more moral authority and lays down some of the core principles that we still apply with continuing refinements to this very day. And one of these principles is the concept that the European Convention on Human Rights is a living instrument to be dynamically interpreted in the light of present-day conditions. Now, this concept of the convention being a living instrument ushered in something of a revolution. And like with all revolutions, there were both positive and negative effects. Insofar as the unborn was concerned, or the unborn were concerned, while the court maintained and still maintains, both directly and indirectly, that it will not read into the convention rights which the framers of the convention never intended to confer, like the right to divorce, as opposed to the right to marry, or the right to an abortion, this dynamic and evolutive interpretation meant that at least one article of the convention, Article 8, could be invoked in an ever-increasing number of situations, some of which involved embryos and the unborn child. In a very famous talk delivered almost 10 years ago by Lord Robert Walker, a judge of the UK Supreme Court, he referred to Article 8 as the indefinite Article 8, and went on to show how the evolutive interpretation of this article opened the floodgates, as it were, in matters of personal autonomy. Indeed, the Strasbourg Court has often recognized that private life is a broad term not susceptible of exhaustive definition. It has been suggested that this was a deliberate choice by the framers of the convention. Vague and indefinite terms were used, so the narrative goes, just because they were vague and indefinite, so that all parties, all state parties, hoping and expecting that the terms will be construed according to their respective points of view, could be induced to sign to the convention. Walker suggests that there was not a complete free-for-all, and I think he was right. From early days, the Strasbourg Court paid close attention to any emerging consensus in the way in which legal systems of the contracting parties dealt with difficult social and moral questions. Balancing both the evolutive interpretation with the consensus aspect, personal autonomy has been held to include the right to take decisions about one's own body and one's own sexuality. It covers, therefore, matters on which religious, moral, and social opinions have changed over time and still differ markedly in different parts of Europe. And this raises, in reality, another issue. Are human rights really universal? The most sensitive matters within the ambit of private life include abortion, homosexuality, transsexuality, and assisted suicide. The Strasbourg Court has treaded its way very carefully through this ethical minefield, paying close attention to any emerging consensus among contracting states, but always allowing a fairly wide margin of appreciation for religious and social differences in the states concerned. In relation to abortion, and I know we're talking really about embryos, but the issue, the principle is the same. In relation to abortion, this can be seen by comparison of two decisions separated by nearly 30 years. That is the decision of the European Commission of Human Rights in Bruggemann against Germany of July 1977, and the Grand Chamber judgment, more recent and more known to many of you, of A, B, and C against Ireland, which was decided in 2010. In Bruggemann, the Commission did not disagree with a decision of the Federal Constitutional Court restricting the scope of Germany's Fifth Criminal Law Reform Act, passed in 1974, so far as it liberalized the law on abortion. And the Commission found that the proposed restriction on abortion was not in violation of Article 8 rights of the mother. Bruggemann remains the foremost decision from Strasbourg where we find this important consideration being made, and I quote specifically from paragraph 59 of Bruggemann, quote, "Pregnancy cannot be said to pertain uniquely to the sphere of private life. Whenever a woman is pregnant, her private life becomes closely connected with the developing fetus," unquote. Now, if anyone were to carry a word search on HUDOC, which is the database of the European Court of Human Rights, which is available, publicly available, a word search on HUDOC reveals that this quote from Bruggemann is reproduced out of all the hundreds if not thousands, of judgments in only 2 judgments. In Vaux against France, a plenary court judgment of 2004, and I have to say, in my partly dissenting opinion, in RR against Poland of May 2011. It has otherwise, this reference to paragraph 59 from Bruggeman, it has otherwise been consigned to oblivion. Vaux, as some of you may recall, was an attempt by a woman to get the court in Strasbourg to declare that the authorities' refusal to classify the unintentional killing of her unborn child as involuntary homicide was in violation of Article 2 of the Convention. In its judgment, the court refused to be drawn into the issue of the beginning of life, considering it unnecessary to examine whether the applicant's pregnancy fell within the scope of Article 2, protection of the right to life. Since in any case, even assuming that Article 2 was applicable, the French state had in place appropriate measures, including legal measures, for the protection of patients' lives and the lives of unborn children, and therefore found that in the specific circumstances of that case, there had been no violation of Article 2 of the Convention. An overview of the case law of the court, of the Strasbourg court, in matters dealing with embryos and abortion, reveals that, in fact, these issues, as I have already indicated, ride, as it were, piggyback, as the English say, on Article 8, sometimes also with this article read in conjunction with Article 14, the discrimination article. The right to life of the embryo and of the unborn child is pitched against the right of the mother to self-determination in matters of reproductive rights. But the basis for the legality, or if one wants to use the word, for the right to an abortion, is not to be found in the Convention, but in domestic, that is, national law. The central issue is never, is there a right to an abortion under the Convention, or is there a right to extinguish an embryo under the Convention? No, the answer has always been a clear no to this. But has the right to private life of the mother been adequately safeguarded by the administrative procedures and or the law of the state concerned? That is the question which the court puts to itself. And that is why we don't have much case law and very scanty case law and very wishy-washy case law on the topic of embryo protection and even to an extent on abortion. What I find extraordinary in this subtle game of legal chess is that while there is agreement all over Europe that the death penalty should have no place in the justice systems of the member states of the Council of Europe, there is 100% consensus on that, these same member states still hesitate to recognize that human life, at whatever stage of development, should also be protected, and that where human life is involved, there is no room for whimsical choice simply to assert so-called reproductive rights. I was always brought up to believe, and this is not a belief tied to any religious formation, but is a philosophical notion, that human life can only be destroyed in the actual necessity in lawful self-defense and in the actual necessity of the lawful defense of another person. This implies that the aggression one is faced with must be unjust, grave, and inevitable. How can an embryo or an unborn child ever present an unjust threat to anyone? That is the basic question. Looking for the Strasbourg case law, for the Strasbourg court the Strasbourg court likes to look for what it calls the European consensus in member states. To me, when dealing with these sensitive issues, it's almost a way like washing one's hands. And in any case, what does European consensus mean when dealing with these things? Apart from the fact that the word consensus, like the word unique, should represent an absolute state and therefore not subject to qualification, seeking a European consensus as to whether something is acceptable or not is very dangerous when one is dealing with fundamental human rights, which are meant to be universal and absolute. I tried to make this point in my separate concurring, not dissenting opinion in SH and others against Austria of November 2011, dealing with in vitro fertilization. But anyway, I will not quote from that decision or from my separate concurring opinion, because I see that time is pressing. I am convinced that the case law of the European Court of Human Rights in matters of embryo protection would have taken a different direction had the Convention had, at its inception, a provision similar to Article 1 of the Charter of Fundamental Rights of the European Union. Human dignity is inviolable. It must be respected and protected, because human dignity, as we know, transcends both birth and death. Finally, a word on freedom of conscience. Article 9 of the European Convention on Human Rights comes into the picture mainly from the aspect of conscientious objection. The objection by a person when he or she is required to do something that that person holds sincerely and on cogent grounds to go against the innermost moral dictates of his or her conscience. It is, of course, not difficult to see how the field of medically assisted reproduction, just as with abortion, this situation can arise. Here, unfortunately, we find a great deficit in the case law of the European Court of Human Rights. Article 9 does not explicitly mention the right to conscientious objection, whether in the military or civilian sphere. Excuse me. Nevertheless, the court has ruled that the safeguards of Article 9 apply in principle to opposition to military service when it is motivated by a serious, insuperable conflict between compulsory service in the army and an individual's conscience or his or her sincere and deeply held religious or other convictions. The question is, why only to military service? Is the deliberate destruction of human life on the battlefield any different in essence from the deliberate destruction of human life in the laboratory or in the womb? At least on the battlefield, one can claim that the person or persons on the other side are hell-bent on killing you. Can that be said of the embryo in the laboratory or of the unborn child? Although there is no precise established definition of conscientious objection, the court in Strasbourg has seen fit to follow the opinion of the United Nations Human Rights Committee to the effect that conscientious objection is based on the right to freedom of thought, conscience, and religion, where it clashes with the compulsory use of force at the cost of human lives. So it has limited conscientious objection in a sense. By applying Article 9 of the Convention, the court has limited conscientious objection to religious or other convictions comprising, in particular, a firm, permanent and sincere objection to any involvement in war and bearing arms. But in reality, the case law is limited to conscientious objection to military service. When it comes to areas not related to military service, Article 8, the indefinite Article 8, seems in each and every case to trump over, I hate to use the verb to trump because it reminds us of something else, I suppose, but in every case to trump over Article 9. The court has persistently even refused to recognize and apply the doctrine of reasonable accommodation when faced with two apparently conflicting rights, the right to private life and of access to certain medical services against the right to freedom of conscience of the medical practitioner. The clearest example of this intransigence and of the relegation of Article 9 to the second division, as it were, in the hierarchy of fundamental rights under the Convention is still, to my mind, the case of Aweda and others against the United Kingdom of January 2013, when one of the 4 applicants was forced out of her job because, as a registrar of births, marriages and deaths in a London borough, she had strong moral objections to officiating at same-sex marriages. After initially making arrangements with colleagues in her office to swap tasks with those who had no such moral issues, a reasonable accommodation which would have had her continue to work at the office without in any way disrupting services which the office provided to same-sex couples. After this, however, she was sacked. The borough in question insisted that she had to officiate also at same-sex marriages. The court, in my opinion, and in that of another member of the chamber, the Montenegrin judge Nebojša Vucinic, in this part, because we submitted a separate, a partly dissenting opinion on this, in this case, the majority conflated, mixed up issues of religious belief with conscience. As one of the third-party interveners in this case, the European Centre for Law and Justice quite pointedly put it, and I quote, "Just as there is a difference in nature, just there is a difference in nature between conscience and religion, there is also a difference between the prescriptions of conscience and religious prescriptions. The latter type of prescriptions, not to eat certain food, to wear a turban or the veil and so on, may be subject to limitations in the manner and subject to the conditions laid down in Article 9, subarticle 2. But can the same be said with regard to prescriptions of conscience? I and my colleague, Judge Vucinic, were of the view that once that a genuine and serious case of conscientious objection had been established, the state is obliged to respect the individual's freedom of conscience, both positively, by taking reasonable and appropriate measures to protect the rights of the conscientious objector, just as in the case of objection to military service, and negatively, by refraining from actions which punish the objector or discriminate against him or her. Freedom of conscience has in the past all too often been paid for in acts of heroism, whether at the hands of the Spanish Inquisition or of a Nazi firing squad. As the European Centre for Law and Justice observed in that case, in the Aweda case, it is in order to avoid that obeying one's conscience must still require payment and heroism that the law now guarantees freedom of conscience. The same, in my view, should apply to conscientious objection concerning the destruction of life, whether in embryonic or fetal form. And I will stop there, Anna, for the moment. Thank you.
Muchísimas gracias, señor de Gaetano. La verdad que yo veo claramente esa partida jurídica que usted ha denominado como una partida de ajedrez entre el bien jurídico, que es el embrión humano, que científicamente es un ser humano, un ser vivo, y el bien jurídico del derecho de la mujer sobre su propio cuerpo. Ese debate jurídico, esa partida entre la protección de un bien jurídico y de otro bien jurídico es el que nos lleva precisamente a este seminario, porque el embrión humano es un bien jurídico porque es un ser humano que hay que proteger. De todas formas, luego sobre esto en el debate yo querría formularle alguna pregunta de las que me han pasado en el chat, pero para avanzar en el programa muchas gracias, señor de Gaetano, quería presentar a Miriam Estiberras. Miriam es presidente de Life Network Foundation Malta, son miembro de la Federación Europea One of Us desde hace muchos años. Y Miriam, en el caso de tu presentación, yo te lo formulo directamente como una pregunta. ¿Cómo podemos recuperar la humanidad y el valor del embrión humano como uno de nosotros, como One of Us? Adelante, Miriam.
Anna, my part of the discussion is about rehumanizing the embryo. And I think this is where we have to get it right. So in the book, A Matter of Life, by IVF pioneers Edwards and Steptoe, the embryo is described as a microscopic human being, one in its very earliest stages of development that is passing through a critical period of its life of great exploration, becoming magnificently organized, switching on its own biochemistry, increasing in size, and preparing itself quickly for implantation in the womb. Medical textbooks of embryology testify to the same fact, that the human being comes into existence as a single-celled organism, the zygote, when the sperm fertilizes the egg. The embryo, fetus, child, and adolescence are but stages in the life cycle of a determinate and enduring entity that is the human being. Nobel Prize winner Robert Edwards, along with surgeon Patrick Steptoe, successfully pioneered conception through IVF, leading to the birth of the first test tube baby, Louise Brown, in 1978. In his book, Edwards also gives this testimony, and I quote, "Thus recollecting at her birth his appreciation of Louise Brown as one or two cells in his petri dish, Edwards said, she was beautiful then and she is beautiful now. This is a testament to the truth and the language that we need to reclaim today. For Edwards and Steptoe, the beauty of Louise Brown as an embryo and that of Louise Brown as a newborn baby inspired equal awe and reverence. What has happened since then? Today, embryos are mass-produced, selected, experimented upon, frozen, disposed of on a massive scale in the IVF industry, and disposed and killed in the millions by contragestive and abortifacient contraceptive medication and apparatuses. What has led to this shift in thought and action? What has allowed our scientists and legislators to overcome their initial awe and respect towards nascent life? To the extent that now the human embryo is left exposed to such abuse. What? The human embryo has been subjected to a process of systematic dehumanization. A study of dehumanization tactics shows how man has applied the same techniques to dehumanize all sorts of groups of people in the past, each time with horrific results. History is replete with examples of systematic holocausts executed in the course of the last century alone. In his opening statement of the doctor's trials on December the 9th of 1946, General Brigadier Telford Taylor remarked, "We have still other responsibilities here. The defendants in the dock are charged with murder, but this is no mere murder trial. We cannot rest content when we have shown that crimes were committed and that certain persons committed them. To kill, to maim, to torture is criminal under all modern systems of law. These defendants, however, listen carefully, did not kill in hot blood, nor for personal enrichment. Some of them may be sadists who killed and tortured for sport, but they are not all perverts. They are not ignorant men." And here is the emphasis. Most of them are trained physicians, and some of them are distinguished scientists. Yet these defendants, all of whom were fully able to comprehend the nature of their acts, and most of whom were exceptionally qualified to form a moral and professional judgment in this respect, are responsible for wholesale murder and unspeakable cruel tortures. It is our deep obligation to all people of the world to show why and how these things came about. And further on, he says, "The wrongs which we seek to condemn and punish have been so calculated, so malignant, and so devastating that civilization cannot tolerate their being ignored because it cannot survive their being repeated. Nonetheless, we see them being repeated upon yet another arbitrary class of human beings, the preborn, including the embryo. The Genocide Watch website, which is very easy to find, illustrates the systematic ways in which ordinary human beings can be made participants in such action. And it is good to try to understand why people are doing this. There are 10 points. Classification sets the subject apart in a them against us perspective. Symbolization makes this easy to visualize in people's minds. Discrimination and dehumanization follow, denying the humanity and status of the embryo and the child in the womb. Organization and polarization attacks and split the defending groups. Preparation and persecution lay down the path to discredit the defenders of life, using scare tactics, while resolution and laws are passed. Ongoing eugenic and other campaigns lead to extermination of embryos, abortion of the preborn child, and after-birth abortion proposals. Denial, reframed as choice, or women's rights, or healthcare, is employed as a camouflage of what actually happens to these lost lives. Pictures of aborted fetuses, testimonies of abortion survivors, ex-abortionists, people who regret their abortion, and many others are ridiculed, silenced, or labeled traumatic. We are at a point where we need to take off the gloves and embark on a life-saving campaign like never before. To begin with, we need to learn how to rehumanize our conversations. The identity of the child from conception to birth must be reclaimed in the media, as well as maternity, both as a privilege as well as the life-bearing gift that it is. To the terms bunch of cells, embryo, fetus, pregnancy, we need to be ready to wed the baby in the initial stages of development or the baby in the womb. The terms termination and fetal demise must be replaced with loss of an unborn baby's life and death of the baby in the womb. When we speak of disposing of embryos, we explain what is actually happening and that an embryo is being killed. Since 2017, we have seen companies now turning frozen embryos into jewelry to be worn with pride and love by their, in inverted commas, parents. Consider this. Not only were these sons or daughters not allowed to grow and develop and be born, but they are now carried around as jewelry. We need to rehumanize disability, especially related to pre-implantation genetic diagnosis, where the affected embryos are discarded, and also prenatal testing, where the sick baby is aborted. Both result in the death of a child before birth. Negative prenatal diagnosis should read pregnant with a sick child. Perinatal hospice should be available for mother whose child has been diagnosed as having a fragile life, just like we support patients given a terminal diagnosis. In conclusion, we have often heard that the humanity of a society can be measured by the way that it treats the most vulnerable, and this applies to nascent human life. On the other hand, we also know that all that is required for evil to triumph is for good men to do nothing. Language is critical. Social engineering is always preceded by verbal engineering, and we have seen and are seeing this all the time. As a matter of human rights, Just as none should be excluded from moral and legal protection based on race, sex, religion, or ethnicity, no one should be excluded on the basis of age, size, or stage of biological development. The state has an ethical and moral obligation to protect embryonic human beings in just the same manner that it protects every other human being. Embryo protection is the only frontier of resistance against abortion. And I repeat, embryo protection is the only frontier that can provide a resistance against abortion. The stakes for life are high. It is high time that we created a worldwide movement to protect nascent human life, to face down the highest institution and insist that enough is enough. Reports such as the recent Matic report cannot be accepted anymore. This report overstepped the boundaries of EU competence, and yet no one intervened to halt it. Why? Why are we allowing ourselves to be overruled and even silenced? We need to regroup and combine our forces into a worldwide movement of life. The time to act is now. Thank you.
Muchísimas gracias, Miriam. Efectivamente es la deshumanización del ser humano a lo que asistimos y particularmente del más débil. En el caso del día de hoy, del más pequeño, pero también de nuestros ancianos. Vemos no solo el avance del aborto en los países europeos, sino también el avance de la eutanasia, por ejemplo, en España tan reciente. Yo coincido plenamente contigo en que una sociedad que no es capaz de proteger al más débil está abocada al fracaso, no me cabe ninguna duda. Y desde luego esa es nuestra batalla y por eso también estamos hoy aquí. Muchas gracias, Miriam. Hoy además tenemos una pequeña sorpresa en este programa y contamos, antes de pasar al debate y a las conclusiones, con una breve presentación del juez federal de Mar del Plata, de Argentina, se llama don Alfredo Eugenio López, que ha alcanzado notoriedad internacional recientemente cuando hace apenas un mes dictó una medida cautelar y ordenó suspender la ley de interrupción voluntaria del embarazo argentino. Ya sabéis que ellos no hablan de aborto, hablan de interrupción del embarazo, por considerar que viola la obligación internacional del Estado argentino de proteger la vida desde la concepción. En su sentencia, el juez ordenó no solo la suspensión de esta ley que les acabo de mencionar, sino también del protocolo para la atención integral de las personas con derecho a interrupción del embarazo, aprobado en el 2019. Es una prueba palpable de la defensa de la vida humana hoy desde sus funciones como juez. A continuación podemos escucharle al juez Alfredo Eugenio López.
Buenas tardes, quiero agradecer la posibilidad que me han dado de intervenir en este foro tan prestigioso y entiendo que la invitación tiene como motivo el fallo judicial que ha ocurrido en Argentina, que he dictado en Mar del Plata, donde ejerzo como juez federal, vinculado a la medida cautelar solicitada por un ciudadano cuestionando la ley del aborto que se sancionó este año en la Argentina, que establece, en pocas palabras, el aborto sin término gestacional. Esa medida cautelar fue revocada por la Cámara Federal, entiendo en forma improcedente, en virtud que no solamente rechazó la medida cautelar, sino la acción de amparo en sí misma, que es la acción que prevé el artículo 43 de la Constitución Nacional. La medida cautelar tenía fundamento en la verosimilitud en el derecho y el peligro en la demora. Peligro en la demora evidente porque se están matando a los niños por nacer. Y verosimilitud en el derecho en virtud de que la Constitución Nacional Argentina prevé en su artículo 75, inciso 23, la protección o tutela de la mujer embarazada y en consecuencia del niño por nacer al que se lo considera niño hasta los 18 años. Y el artículo 75, en su inciso 22, que establece los tratados internacionales como parte del bloque constitucional, como la Constitución misma, y tanto el Tratado de los Derechos del Niño, del cual Argentina ha hecho expresa reserva que considera persona a partir de la concepción, como así también el Pacto de San José de Costa Rica, que considera que hay vida y persona humana a partir de la concepción, y por supuesto el propio derecho interno, el artículo 19 del Código Civil reformado, que establece que se es persona a partir de la concepción. De manera tal que era abrumadora la normativa legal que protegía al niño por nacer. Pese a ello, y en base a un fallo anterior a la reforma del Código Civil que aludí, del artículo 19, se modificó lo que era un delito por parte de la Corte Suprema, contrariando la jurisprudencia tradicional de que el derecho a la vida es el primer derecho y fundamental, sin el cual no se pueden ejercer otros derechos, y como decía, transformó lo que era un delito en un derecho. A partir de allí, entrando por la ventana de la legislación argentina, se establecieron protocolos de aborto por vía administrativa, porque la misma Corte instó a que se hicieran esos protocolos. Vuelvo a repetir, esto fue anterior al artículo 19 reformado, es decir, que la situación jurídica no es la misma hoy. Mi decisión ha sido apelada y entiendo llegará a la Corte Suprema, que en definitiva resolverá el asunto. La vigencia de la misma fue de apenas una semana, pero según informes fidedignos, en la capital federal de Argentina fueron 100 vidas las que se salvaron con motivo de mi decisión judicial. Eso causó, por supuesto, una reacción de los sectores feministas abortistas que intentaron incluso vandalizar el juzgado, pero previa a su llegada llegaron sectores defensores del niño por nacer que impidieron que se atacara mi sede judicial. En definitiva, creo que esta es una lucha en la cual debemos comprometernos, porque la verdad, el derecho natural y, como en mi país, el derecho positivo están de nuestro lado. Creo que es un combate difícil, pero si no defendemos al niño por nacer, creo que ningún otro derecho es superior al derecho a la vida y, en consecuencia, carecería de sentido cualquier derecho y viviríamos en una tiranía.
Muchas gracias. Ahora, a continuación, yo quería formular algunas preguntas que han lanzado a través del chat. Y, en primer lugar, quería formular una pregunta al señor de Gaetano. Esta pregunta va un poco en función de la primera parte de este seminario, en el que hemos visto cómo las nuevas tecnologías, como en particular todo el estudio del embrión humano, nos hace ver desde el verdadero primer instante el milagro de la vida, ¿no? ¿Cree que este avance científico, en el que nos muestra de manera científica y real el inicio de la vida, puede traernos de algún modo un cambio legal? ¿Puede ayudar este avance científico a que se produzca un cambio legal real en la protección del no nacido? Gracias, señor Gaetano.
Of course, we are always discovering new things about the beginning of life, really. I always say that the world's greatest mystery is, in fact, the beginning of life, but I mean it in a more cosmic sense. But even when it comes to life in the embryonic form, we are always learning more and more. And of course, yes, the more we learn about the fact that really in the embryo there is the human being in theory, as it were, you know, in the making. And the more we learn about that, yes, we should be protecting human life from the very beginning. But as Miriam, I think, said quite rightly, at the moment, there is a campaign of, well, one could call it misinformation, disinformation, or even perhaps intimidation, which actually prevents many people from actually speaking out of fear of being labeled reactionary, outmoded, outdated, Taliban Catholics or whatever, when what is an issue here has nothing, well, has to do with religion, but it is something different, because it is not only in the Catholic or Christian religion that one actually wants to protect life. I mean, even an atheist who does not believe in God, or in a God, in a supreme being, can still understand that there is life in an embryo and may wish. So the answer to the question is yes. The more we get to know about the beginning of life, the more there is the possibility that we protect this life from the very beginning, from its embryonic form. But that depends on whether we have in our respective parliaments people who are really interested in knowing this, rather than in getting votes by being populist with certain aspects of legislation. I'm not thinking only of legislation on embryo protection and so on, but on many other fields. I mean, one of the key problems today, even in some of the most democratic states of the world, or allegedly democratic, between inverted commas, states of the world, is this issue of populism, which stifles, as Miriam quite rightly pointed out, reasoned debate.
Sí, señor de Gaetano, y la siguiente pregunta es relativa al informe MATIC, que imagino que usted conoce como antiguo juez del Tribunal Europeo de Derechos Humanos. ¿Qué le parece la aprobación de este informe MATIC? Y, por ejemplo, sin ir más lejos, en el caso que usted ha mencionado, de la eliminación del derecho a la objeción de conciencia.
Well, what can I say? I have expressed myself so often in favor of conscientious objection, not only in matters of abortion or conscientious objection is something which has to do with a person's belief in what is essentially good or bad. We make these choices daily in our lives. It has nothing to do with one's religious beliefs or one's religious convictions, as again, people who may have no religious convictions whatsoever can know in their innermost conscience what can be right and what can be wrong. To eliminate that is to try to say, in reality, to try to defeat or to go against the reality of life, because everyone has in his innermost this idea of what is right and what is wrong. Of course, provided that conscience is properly instructed, because you may have instances where people, out of a misguided sense of conscience, think that they can do anything. I mean, in Strasbourg, a few months ago, there was a decision about a case. It's called the Naked Ramblers case. A chap in I think he's Scottish, probably not English, who thought that he had a right to go rambling or walking in the countryside completely naked, and he actually invoked his freedom of conscience when he was repeatedly arrested by the police, both in England and across the border in Scotland. I mean, conscience has to be properly has to be properly, cultivated. But, conscience can even go against, in a sense, against the word of a pope. I mean, remember what Cardinal Henry Newman once wrote in a famous pamphlet. I don't remember the name, but it's quoted in one of my separate opinions about conscience and the word of the Pope. Of course, there Newman was talking about Pope Pius IX, who wasn't exactly the most liberal of popes. But he said, if I had to, bring religion, if I had to bring, if I had to bring religion in after dinner toasts, I would drink to conscience first and then to the Pope's word, because conscience really, is something so important. So trying to annihilate conscientious objection in a matter which is so vital, apart from the fact, of course, that in doing so, one risks truncating, one risks damaging the medical profession. Because what will happen? Possibly the best people or the brains that could become, for instance, let's say, doctors in what do you call them? The people who carry out births. Miriam, what do we call them in English?
The obstetricians.
Obstetricians, people who, men and women, of course, who want to go into obstetrics and gynecology. If there is no right to conscientious objection, some of the best brains will simply either not go into medicine at all or opt for something which is less, perhaps not attractive, but it's less morally complicated, like, I don't know, hematology or dermatology or something of that sort, you see? So to try and stifle, and then why, this is the point, why do we have conscientious objection for military service, but then deny or try to stop it, to prevent it in other services? It simply makes no sense. There's no logic in it.
Finalmente, para concluir este seminario, contamos con la participación de don Julio Tudela Cuenca. Don Julio Tudela es de la Universidad Católica de Valencia, es doctor en farmacia, miembro del Observatorio de Bioética de la Universidad de Valencia, colaborador de One of Us. Don Julio, tienes mucha materia esta tarde. Muchas gracias y tienes la palabra para las conclusiones. Gracias.
Muchas gracias, Ana. Muchas gracias a todos los organizadores de este webinar por su amable invitación y también a los participantes por sus valiosas ponencias y a todos los que siguen esta webinar por su compromiso en favor de la vida y de la dignidad humanas. Voy a hablar brevemente a modo de resumen y también como una ilustración de los atentados contra la integridad, la vida y la dignidad del embrión humano, que no se reducen, como voy a explicar brevemente, al tema del aborto. Sí es verdad que la destrucción de los embriones humanos se polariza, en primer lugar, en el aborto, al que tristemente hemos asistido recientemente a una matización que, como comentaba Ana, viene de la mano del informe MATIC, que establece algo impensable hasta ahora: reconocer el aborto como un derecho e ignorar el derecho del nonato, del niño por nacer. Pero no solo el aborto es la fuente de aniquilación de embriones humanos. Todos los embriones que ya se han comentado en la exposición de hoy, en las exposiciones de hoy, todos los embriones sobrantes de las técnicas de fertilización in vitro, que en su gran mayoría están destinados a su destrucción. También muchos de estos embriones, antes de ser destruidos, van a ser desviados hacia la experimentación clínica, la investigación de enfermedades, de la propia embriogénesis, la obtención de células troncales con fines terapéuticos, la clonación, etc. Todas estas investigaciones sobre estos embriones los condena a su destrucción. También, como se ha comentado en una de las ponencias, los embriones que han sido descartados tras el diagnóstico genético preimplantacional, una auténtica técnica eugenésica que favorece a los perfectos y elimina a los defectuosos. Por último, otra forma oculta y silenciosa de destrucción embrionaria viene de la mano de algunas técnicas contraceptivas que, no impidiendo la fecundación, interfieren en el proceso de anidación del embrión en el endometrio, provocando verdaderos abortos en el sentido estricto de la palabra. Quiero mencionar específicamente las técnicas de contracepción de emergencia, de implantación creciente, de más reciente aparición y que, después comentaré, presentan efectos devastadores. En segundo lugar, hay otra forma de atentar contra la vida del embrión, que es esta eugenesia o selección embrionaria. Es decir, como se ha afirmado, el diagnóstico genético que está incrementando sus niveles de sensibilidad, pudiendo afinar en cuanto a la información genética de los embriones, que está provocando la eliminación de muchos embriones con pequeñas alteraciones genéticas, que no van a afectar a su salud futura, pero que se alejan del patrón de perfección buscado. Esta es una verdadera técnica eugenésica y condenable. Además, puede utilizarse el diagnóstico genético para la selección de características embrionarias deseadas, el sexo o condiciones de compatibilidad para trasplantes futuros de hermanos, etc. Una tercera forma de agresión contra la vida embrionaria viene de la mano de la edición del material genético de los embriones. El creciente perfeccionamiento de las técnicas de edición genética que también han sido nombradas esta tarde permite la manipulación genética del embrión en sus primeros estadios de desarrollo, con el fin no solo de corregir defectos genéticos, en principio una intervención lícita, sino también de promover el enhancement, el perfeccionamiento transhumanista o posthumanista de la especie humana, alejándolo de su codificación natural. Esto presenta riesgos incalculables. En cuarto lugar, un nuevo atentado contra la vida embrionaria viene de la mano de las nuevas técnicas de hibridación y quimerismo embrionario, es decir, obtener individuos que poseen material genético procedente de la combinación de diferentes especies, bien en su totalidad, serían los híbridos, o bien en algunos de sus tejidos, serían las quimeras. En los últimos años se han obtenido quimeras de humano y cerdo y más recientemente de humano y mono, con la pretensión, por un lado, de favorecer la investigación en el desarrollo embrionario temprano y por otro, de en un futuro poder obtener órganos humanos desarrollados en embriones animales como material para trasplantes. Seguidamente pasaré a hacer un análisis de las dificultades bioéticas que entrañan estos procesos. Por último, un nuevo atentado a la vida y a la dignidad embrionarias viene de la mano de la clonación, la producción de embriones, copias, clones de otros. Me falta una sexta cosa, la ectogénesis. La ectogénesis presenta también la posibilidad de trasladar la gestación del embrión desde el útero materno a úteros artificiales. Esto, que se ha hecho ya con animales, con grandes prematuros, ya hay quien lo propone como sustituto de la gestación maternal para convertir el proceso de la fecundación y la gestación en un proceso totalmente artificial. Quisiera decir una cosa que no quiero que se me pase, y es algo que tenemos muy reciente, la aparición de los embrioides, o sea, los llamados blastocitos humanos inducidos y blastoids en inglés, que persiguen el estudio del desarrollo humano formando algo parecido a un embrión humano a partir de células humanas maduras, reprogramando estas células humanas maduras por una técnica que ya fue definida por un investigador que ganó el premio Yamanaka, que ganó el premio Nobel gracias a estos experimentos, redefiniendo el material genético de una célula humana madura podemos retrotraerla hasta el estado embrionario primigénito. Es decir, podemos pensar en la creación de embriones a partir de células humanas maduras, por lo tanto, obviando, haciendo un bypass al proceso de reproducción sexual. ¿Qué tendríamos que decir como argumentos bioéticos en contra de estas técnicas que acabo de apuntar? Primero, como se ha dicho esta tarde perfectamente, yo no voy a insistir más sobre ello, existe el derecho a la vida, no existe el derecho a matar, como pretende extender el informe Matic ahora. Es reprobable todo acto dirigido a provocar la muerte de un ser humano en estado embrionario. Algo muy importante en bioética, la autonomía de la mujer no le permite conculcar el derecho a la vida de su hijo, como se pretende en el informe mencionado. Por último, los abortos preimplantatorios, los abortos preimplantacionales, que vienen de la mano de las técnicas contraceptivas, también deben ser mencionados, aunque son silenciados y no contabilizados. Con la contracepción de emergencia se suprimen un promedio de 5 embriones por cada 100 píldoras asumidas. Por cada 100 píldoras contraceptivas de emergencia administradas, se pierden un promedio de 5 embriones. Eso suponen millones de embriones al año en el mundo. En cuanto a la reproducción asistida, las técnicas de fecundación in vitro o de inyecciones intracitoplasmática de espermatozoides, debe cesar la producción supernumeraria de embriones por estas técnicas, como también se ha mencionado por alguno de los ponentes, pues su destino, en la gran mayoría de los casos, es su destrucción y su criogenización, es decir, su conservación bajo congelación, supone un trato degradante, dada su condición de individuos de la especie humana. La experimentación con embriones tiene el grave calificativo bioético de que su destino, el destino de estos embriones, es indefectiblemente su destrucción. Son pérdidas embrionarias y deben denunciarse las propuestas utilitaristas que lo justifican en aras del progreso científico. En cuanto al diagnóstico genético preimplantacional, esta tremenda técnica, cuando se utiliza con fines eugenésicos, constituye una forma inaceptable éticamente porque discrimina a los seres humanos y viola la dignidad de los más vulnerables. Cosifica al embrión en función de la utilidad que se le asigna. La edición embrionaria, la edición genética sobre los embriones, presenta la posibilidad de modificar el genoma humano y conlleva un grave riesgo para la integridad no solo del embrión, sino de la propia naturaleza humana. La imposibilidad de ejercer un control suficiente sobre los procesos de alteración genética que vienen de la mano de estas técnicas de edición genera serias incertidumbres sobre sus impredecibles consecuencias. La posibilidad de extender las técnicas de edición genética embrionaria más allá de la simple corrección de errores genéticos abre la puerta a propuestas de enhancement o diseño a la carta que constituyen en todo caso un atentado contra la dignidad de todo ser humano. En cuanto a la hibridación y el quimerismo embrionario, la obtención de especies híbridas o quiméricas pone en riesgo la integridad de la naturaleza humana. Conlleva incertidumbre sobre el alcance de estos experimentos, el impredecible grado de colonización de los tejidos animales de los embriones utilizados por parte de las células humanas injertadas puede presentar formas tan graves como la proliferación de células humanas en los propios cerebros o las gónadas de los animales involucrados en estos experimentos. El fin lícito, que supone la obtención de órganos humanos para trasplante, debe confrontarse a los riesgos del proceso que condicionan su aceptabilidad ética. Por último, la producción artificial de embriones. Las experiencias de clonación humana en marcha desde hace bastantes años con fines de experimentación suponen un atentado contra la dignidad humana, no solo por la destrucción a la que están destinados estos embriones, sino por la violación que supone toda clonación sobre su individualidad y el derecho a la salvaguarda de la identidad genética de todo individuo, que que en este caso es programada. La posibilidad de que en el futuro sea permitida la clonación reproductiva, es decir, obtener individuos al nacimiento fruto de la clonación, agravaría aún más estas circunstancias por las consecuencias que pudieran derivarse sobre los individuos producidos y su utilización por parte de la sociedad. La posibilidad de obtener embriones humanos, actualmente pseudoembriones o embrioides, al margen de la reproducción sexual, constituye una grave amenaza no sobre el propio ser humano solo, que es cosificado como ocurre con la clonación, sino sobre la propia línea evolutiva de la especie humana. Estos experimentos deben controlarse para que los embrioides producidos no lleguen a asemejarse a los embriones humanos de manera que debieran ser considerados como tales. Por último, la ectogénesis o gestación artificial se abre hoy como posibilidad de futuro para convertir la transmisión de la vida en proceso totalmente artificial, excluida la reproducción sexual y la gestación maternal. Como epílogo, me gustaría deciros, trabajemos para que estas amenazas, presentadas tantas veces como frutos del progreso técnico y científico, dejen de suponer un atentado contra la dignidad humana, especialmente sangrante en el caso de los seres humanos más indefensos y vulnerables, los sin voz, los embriones humanos. Deben desenmascararse estos intentos como verdaderamente regresivos, involutivos, contrarios al progreso, a la libertad y a la dignidad de las personas, porque promueven la desigualdad, la discriminación, la manipulación, el sometimiento y el exterminio de los más débiles. Quiero agradecer a los ponentes sus esfuerzos en la dirección correcta, la que respeta la vida humana y la dignidad y los derechos de los individuos. Esfuerzos que desempeñan en sus distintos ámbitos, legales, científicos, políticos, prepolíticos, sociológicos, filosóficos o antropológicos, dirigidos a que el embrión humano, en todas sus formas, sea reconocido y tratado como uno de nosotros. Gracias a todos. Y me gustaría terminar con las palabras de San Juan Pablo II. La vida vencerá. Esta es para nosotros una esperanza segura. Sí, la vida vencerá, puesto que la verdad, el bien, la alegría y el verdadero progreso están de parte de la vida. Y de parte de la vida está también Dios, que ama la vida y la da con generosidad. Muchas gracias.
Julio, por estas conclusiones. La verdad que podemos responder desde aquí para motivar al compromiso, a nuestro compromiso con la vida por nacer, pues creo que tú ya lo has resumido en estas conclusiones: por la vida, por la libertad, por la dignidad y por el progreso. Para todos, muchísimas gracias por vuestra participación y seguimos en contacto y en esta lucha por la vida y por la dignidad de cada ser humano. Muchas gracias.